Hello guys, so I will start from here in this video, this box. Illustration it is how the different forces of state interact in a single administrative action. A person can be in jail only when he has violated law, which is obviously made by the legislature because legislature's work is to make laws. So if any person has violated that law, then as a punishment that person is entitled to a certain period of time in prison. Executive implements the law. The prosecution who charged the person with crime. Judiciary magistrate who decides on person's arrest must also agree that there are reasons to curtail this person's लिबर्टी. लिबर्टी मीन्स फ्रीडम. इतने फ्रीडम से वो घूम रहा था तो थोड़ा उसमें रिस्ट्रिक्शंस लगाना, बिकॉज व्हेन ही विल बी इन प्रिजन ही विल बी नॉट फ्री इन द वर्ल्ड. His movements, his actions will not be free. It will always be under the monitoring of a person, that is jailer, or the in charge of that prison in which he will be uh, imprisoned, right? So there are reasons there because he has committed such a ill act. So he is entitled to some restrictions and his liberty will be lessened to an extent. All three forces have to mutually interact for any kind of an outcome. Montesquieu gave separation of powers a socio-scientific and structured meaning. Now we know how the powers are separated between the three organs of government. Montesquieu's theory has three aspects. Institutional separation or structural separation means that members of one organ of state must not be the members of another organ. I guess we have done this in class 11th or so. That one person cannot hold office in more than two branches of the government and neither in all the three branches of the government, because then the decisions may be biased. So institutional separation means at the institute level the members of those institutions should also be different. No same person will be in any two or three organs. In US, president does not sit in Congress. In India, prime minister and his cabinet also participate in legislature. So India is very flexible system of separation of powers. One organ should not exercise functions of other organs means one organ should not step into the shoes of the other organ. It should not interfere with the working of another organ. It should not do the functions that the other organ is entitled to perform. Aforesaid points can be fully implemented only in an idealistic circumstance. Doctrine of separation of powers in classical sense is not applicable to any modern government, and some overlapping among different organs is inevitable. So these things are to be implemented in an ideal situation, and ideal things generally do not happen in reality, so there is some sort of overlapping. If you remember, we also did in class 11th about sometimes subordinate jurisdiction, subordinate administration, when executive also performs some functions of legislature, because it is not practically possible for legislature to look into all spheres of law. So in that case, sometimes executive acts as a legislature body. If you remember, you must have read about this in your class 11th. Hence, doctrine of separation of powers has adapted to relative circumstances of a polity in different ways than Montesquieu envisaged. Both rule of law and separation of powers together establish administrative law is not an exclusive domain of executive. Means it's not only the part of executive. In fact, such is applicable to each branch of state. Now, role of principles of natural justice: no bias and right to fair hearing. The person will not be in favor, or the judge will not have prejudice or bias towards a particular party to that suit, and each of the two parties will have a fair and equal right to be heard in the court, and then only the verdict would be delivered. Principles of natural justice are not fixed rules, they are flexible, can be molded to suit the requirements of situation or specific purpose to do justice in any particular case. So, these are very flexible rules or provisions that can adapt or that can be molded, that can be shaped as per the case requirements. For centuries, courts have developed two principles, namely rule against bias and rule of fair hearing. These principles are not written in any act, they are derived from law of nature. You did law of nature, class 11th. So they are that's why it is said no principles of natural justice. So they are derived from natural law, they are nowhere written. It is considered to be just with everyone. It is considered that you may not develop a prejudice in favor of somebody. You may not be from the very beginning, I'm not liking this person because he's of black shade or he's poor, so now you have developed prejudice against him. That should not happen. Even if that person was correct, you have delivered a wrong verdict just because a prejudice was developed in your mind. That should not happen. You should treat everybody equally, and a fair chance of hearing of both the parties should be given. Such has been the evolution of administrative law that a third rule of transparency and reasons can also be added. Now there are two rules, rule against bias and rule of fair hearing. Third rule is transparency. You know what transparency mean? Reasons alone show application of mind in decision making. These different shades of natural justice can be best explained through examples. If a workman assaulted a manager in a factory and same manager is appointed as inquiry officer, such an administrative action is clearly hit by a rule against bias. Why? Because like for suppose there is a manager and there is the manager assaulted this workman, and the same manager is there in the committee which has to decide whether this person committed a correct act or a wrong act. So if he is himself the judge, then he will decide in his favor. अगर आपसे ही पूछा जाए आपने सही किया है गलत उसे असॉल्ट करने में, क्या आप कभी जनरली ह्यूमंस नहीं मानते कि उन्होंने गलत काम किया है? So if he is a judge in his own case, he will definitely not say that I am wrong and give me the punishment that is liable on me. So that is rule against bias. And if you remember, we had already done this principle that nobody can be a judge in his own case. I told you about this, I remember. Administrative officials are required to act under consideration of principles upheld by Constitution and not to act with prejudice. Whatever principles of Constitution say, whatever the different rule books or different acts, different statutes, different bylaws state, the judges or the administrative officials have to work according to that. In a case where bias is alleged, there must be a real likelihood of such or actual bias and not mere baseless suspicion of bias. अगर ये इल्ज़ाम लग रहा है that there is a bias, तो वहाँ पर एक्चुअली में वो बायस होती है, सिर्फ शक नहीं होता है. जहाँ इल्ज़ाम लगा मतलब वहाँ बायस थी. कुछ ना कुछ रिलेशन निकल आता है एक पार्टी का और एक ऑफिशियल का. Even in cases when there is a necessity and bias has a reason given circumstance, administrative action is not vitiated. Bias can be of many types. Pecuniary bias. Pecuniary is related to money. Subject matter bias. पर्सनल बायस, डिपार्टमेंटल बायस. जिस पर्सन के अगेंस्ट इंक्वायरी है वो सेम डिपार्टमेंट का है उस पर्सन के जो यहाँ जज है. पर्सनल बायस, पर्सनल कुछ रिलेशन निकल गया. सब्जेक्ट मैटर बायस, कुछ जो सर्कमस्टेंस थे केस में उसका कुछ रिलेशन आ, पेक्यूनरी बायस, उसने उसको पैसा खिला दिया तो वो प्रेजुडिस हो गया कि हाँ अब तो हमें इन्हीं की तरफ वर्डिक्ट देना है. There may be significant overlapping in their shades and kinds. There are certain guidelines which must always be followed. Every aggrieved person has a right of notice as regards his own wrongdoing and material which proved the same on basis of which action is taken against him. So every aggrieved person has the right to notice ki what wrong action you have done, and according to which section of which rule book cases are alleged upon you, and according to those provisions only such and such actions will be taken against him. एक ऐसा नोटिस उस aggrieved person को दिया जाता है. There is a right of cross-examination which accrues to parties whenever the veracity of evidence presented is put to question. If there is a benefit of doubt, or if the evidence is put to question कि evidence पता नहीं actual है या नहीं, या सही है या नहीं सिचुएशन के हिसाब से, तो क्रॉस एग्जामिनेशन हो सकती है. सेल्फ एग्जामिनेशन, क्रॉस एग्जामिनेशन दो टाइप की होती हैं. लॉयर ऑफ पार्टी ए कैन एग्जामिन द any of the witness of party B, and party B, lawyer of B can inquire any of party A. That can happen. That is cross examination. इसका इससे पूछेगा, इसका इससे पूछेगा. क्रॉस, अगर बी वाला, बी पार्टी का लॉयर बी पार्टी के ही किसी विटनेस से पूछ रहा है तो वो सेल्फ एग्जामिनेशन हुआ. A party always has a right to present his case or to go for legal representation, and then there are constitutional safeguards in place which further govern administrative action, such as Article 311 which protects the civil servants. जो भी government के servants है, for protecting them we have Article 311. Please remember all the articles which are mentioned hereby. Every person has a right to be represented in a court of law. Legal remedy का right सबको है. Delegated legislation, hotspot of administrative law studies. To put it simply, when legislation proceeds from an authority other than supreme authority and is dependent for its continued existence as well as validity on supreme authority, it is called delegated legislation or subordinate legislation. I told you just few minutes before about this thing. It is a natural companion of intensive form of governance, meaning that when a governance setup is so spread out that it is not possible for the top legislative authority to directly reach out to grassroots on its own strength, it can be legitimately expected that rulemaking would vest in appropriate and corresponding administrative authority. So, subordinate legislation is when legislative authority, that is the supreme lawmaking body or the parliament in India as such, is not able to look into all the spheres of law, because India is so a big country and governance system is also so spread out that it is not possible for it to look into various aspects. So then the executive or some other organ or some other institution of government can take into the functions and it can make some law. So that is when we say delegated legislation, means as a representative or in place of legislature some other body is doing the works. This also opens the avenues of specialization of law, where regulation can be more aptly framed for specific need of different regions in a diverse land like India. So it can also be in place where rules and regulations are to be more specifically framed for taking into consideration the various particular needs, because as you know, India is a very diversified country. It has so many variants of religions, of races, of castes, and different linguistic basis religion people. There are various languages speaking people, right? So India is a land of diversities. So if these conditions are so different for different people, so there may be that their requirements, their wants are also different. So based upon the region, based upon specific needs of the people living in that region, so based upon those specific needs, regulations need to be framed in that localized area also. So that can be more aptly, more correctly, and more efficiently done if not only the legislature has its duty to frame laws, but those localized bodies can also frame laws in its place. Crisis emergency legislation is also possible in such a situation. However, it must be remembered that no delegation must be unfettered, as no democratic society can ever afford an uncountable authority to govern against the popular will of people. Means there must not be any delegation or any authority which is acting as a representative of the supreme authority that says that okay, I will be doing your work, but I will not be accountable to any person, I will not be responsible to any person. So that is wrong, because if this happens, then there is no meaning of having a democratic society and a democratic government in place in that country. So it is very important that apart from the legislature, which is obviously accountable and answerable and responsible to the general public of the country, the delegations that it has, they are also responsible and accountable to the general will of the common public. Hence, delegation of lawmaking power to administrative authorities has been shown in a welfare state often controlled, because they are accountable to the legislature and legislature is in turn accountable to the general public. So the situations in a welfare state or in a democratic society is often under control. In view of our written constitution, such delegation cannot be unlimited and must always conform to basic features of constitution as well as the ambit which is given for delegation by the corresponding legislation. So it is entitled to certain restrictions, its jurisdiction is limited. Whatever jurisdiction or whatever arena that legislation is providing to the delegated one, it has to control itself under that arena only, and also it has to conform to the basic features or basic principles which are mentioned in the constitution. It cannot exceed its legs out of the arena which is provided to it. उसी चीज़ में काम करना है, उसी एरिया में काम करना है जो कि उसको दिया हुआ है, उसके ज़्यादा वो काम नहीं कर सकता. अगर इतना एरिया उसको दिया हुआ है काम करने के लिए, तो इस एरिया में आके यहाँ पर आके वो काम नहीं कर सकता. इट हैज़ टू वर्क अंडर इट्स ओन एम्बिट ओनली. Essential legislative functions cannot be delegated. जो important काम है which can solely be done by the supreme legislature authority, उनको आप किसी और को नहीं दे सकते. That you cannot give. While appreciating the doctrine of delegation of powers, care must be taken in not reading too much into it. मतलब सारा ही काम आपने डेलीगेट कर दिया, नाउ यू आर फ्री. लाइक प्राइवेटाइजेशन जो आजकल हो रहा है ना, आपने सुना होगा. तो ये सब क्या है, ये सब डेलीगेटेड है कि अपना काम वो सब प्राइवेट कंपनीज को दे रहे हैं. ये एक सॉर्ट ऑफ डेलीगेटेड आप बोल सकते हैं, एक तरह का एग्जाम्पल है. बट जो इम्पोर्टेंट वर्क्स हैं, जो असेंशियल और कोर मैटर्स हैं, उनको यू कैन नॉट गिव टू अदर पीपल टू वर्क अपॉन दैट, एंड यू हैव टू टेक केयर, यू हैव टू कीप अ चेक ऑन इट. एंड बहुत ज़्यादा किसी भी चीज़ का अगर हम लिमिट्स एक्सीड कर दें, हद तक चले जाएं, अति कर दें, सो वो अच्छी नहीं होती. किसी भी चीज़ की अति अच्छी नहीं होती है. सो एज वो है कि यहाँ पर भी डेलीगेशन ऑफ पास इतना ज़्यादा नहीं होना चाहिए कि वो फिर उसका मीनिंग ना बचे. For example, the parliament cannot be called delegate of people, as people have given to themselves the constitution. It is written in our preamble that we hereby adopt and give ourselves on this date the constitution. So we have ourselves given the constitution to us. So parliament cannot be said that पीपल ने अपना काम पार्लियामेंट को दिया है, नहीं, कॉन्स्टिट्यूशन ही हमने अपने आप अडॉप्ट किया है, हमने अपने आप को दिया है. तो पार्लियामेंट कैन नॉट बी सेड टू बी द डेलीगेट ऑफ द जनरल पीपल. Within that particular limit, Parliament as an organ is supreme and not a legislative agent. I am saying it. Parliament is the supreme lawmaking body, that is the supreme legislature in India, in the context of India. Then, from here, administrative law in ascertaining the policy of any given legislation, I will be continuing in the very next video that will be uploaded.